Good to me.
Yeah, as long as the clock is running, you should be all set.
So I can't do anything but FTR.
Yep. That computer's locked to just be FTR.
Get back to it. Are these unmutable?
Which one?
The witness gallery viewing. Oh no, it's just very delayed right now. So now I'm going to do the voting. And then I'll leave.
You're not using the gallery mic, right?
No,
Okay.
but it's not. That's still.
There we go. All right. Looks like they're all muted now, but the podium.
Which is what we want. And why is that? Just does it default right to?
Oh no, there's a controller right
Oh,
here.
you're doing it from there?
Yeah.
Well, thank you for your patience.
Of course. Yes, this is Hager's, right? Yes. It's always a fear when I have back there. I'm never do the wrong one. 2015.
And did you want?
I am going to do 2 minutes on this one, yes.
And what about?
3.
I think once. Chelsea lives, yes. 2018.
Okay. And you want?
3 minutes.
Did you work with before?
Once.
You did. Okay. You just did it.
It was at high school.
It was.
Yeah. Skowhegan.
Oh, okay. Either of you have any problem installing from where you are? I don't think you
Yeah.
won't be able to
Oh,
see
yeah.
from
Yeah.
there. Any questions?
I don't think so.
So I think the court probably will invite you back since you didn't have the opportunity to do that at high school.
Good morning, you can be seated. The first matter before the court is Penobscot 2437, State of Maine versus Scott Havens. Council appear to be present, and I assume ready to proceed. If you would identify yourselves by saying your names for the record, please, starting with the appellants.
Good morning, Rory McNamara for the appellant, Scott Havens.
Good morning, Chelsea Lenz for the state.
Thank you. We are, I believe, being streamed live on the web. We had a little technical difficulty to start this morning, but I think we have overcome that. And with that, counsel, we'd be happy to hear your argument. Attorney McNamara.
Thank you. May it please the court, counselor. If this court signs off on Section 358, the political branches of government will be free to exempt their favored parties and witnesses from offering direct examination. Trials will then consist of defendants attempting to rebut out-of-court presentations. It's no exaggeration to say that this portends a seismic shift in trials as we have always known them. This court will have then construed the Maine Confrontation Clause to offer no protection against the resulting sea changes. Face-to-face testimony, or if severe distress is likely to ensue, testimony at least within the presence of the defendant has always been required. Without it, several rights and assurances of reliability are eliminated. A defendant's own right to appear is diminished, as is the right to a public trial, because the most important part of trial would be a video recorded months or years prior and out of court. Unsworn quasi-testimony will be permitted. Fact finders will only be able to assess credibility to the extent the video recording permits it. The state's burden of production will be diminished. Defendants will be tried with guilt-suggestive technology. This court should hold that Section 358 violates the State Confrontation Clause, and I happily cede back any time and welcome any questions from the court.
And just to be clear, I know that the green light was on, but I also was aware that you had protected
I didn't even notice. Thank
2
you for doing
minutes.
that.
And I think we all knew that, which is why we didn't jump in. Oh, you don't have a remote for the light? Okay. All right. In any event, the green light now being on, can I move to the other issue, which is the specific unanimity?
Yes.
Is that was not preserved?
Correct.
Is that structural?
No, it's not a structural error, although, as the court in the White decision said, that prong of harmlessness, so here it's a little bit different. We have the third prong of the obvious error test as opposed to the White decision was about harmlessness. But they both essentially go to substantial rights. Injury to substantial rights may be something more than just whether or not that outcome was affected or there's a reasonable probability of affecting that. And I have argued before that it is appropriate to hold in several decisions where there is a lack of a specific unanimity instruction. That is something that this court should automatically reverse for, because it is something I believe that the trial courts have seen decision after decision from, and it's still not being given. And I think it should be given as a matter of course. It's not a difficult instruction to give, and it's one that is appropriate.
So our jurisprudence has kind of created a tipping point, saying if counsel expressly waives it, then
Yeah.
it's gone, but if not, it isn't. And there may be circumstances where counsel might decide that they don't want them. Maybe they feel they've impeached the testimony completely. Don't want that, they want to focus right down on that issue, and they expressly waive it. But I'm asking you, is that a distinction that holds water, that us holding out to say, if there is an express waiver, then it's gone. But if not, if it simply is not given, then it is error. Is that a valid tipping point?
Yeah, and I do think there are two components to that. I think it would be one, foolish for any defense lawyer to say that I don't need a specific unanimity instruction. Other cases, other sorts of instructions, it may be perfectly within a strategy. I don't really see that with specific unanimity. It just doesn't seem to fit any strategy whatsoever. But yes, under this court's case law, under case law about waiver generally, an express waiver, meaning that instruction there I'm declining that.
But if
That's
it's so
waiver.
well-known, I mean, presumably defense counsel, competent defense counsel would know, okay, we all agree this is multiple offenses taking place in a range, we need specific unanimity. If they don't ask for it, how is that not an implied waiver?
I think the same way it's not a waiver, well, lack of a waiver isn't the right term here maybe, but the same way it's not a.
It's a forfeiture.
Right.
This
we do-
waiver requires voluntary.
Thank
and
you, yes. And
But
it is,
Why
sorry.
isn't it a forfeiture? Haven't we said in the past you've got to ask for it?
oh, it's absolutely a forfeiture in the sense that we've forfeited the proper standard of review, a de novo standard of review. And that's the way I understand case law and the distinction between forfeiture. You're forfeiting a standard of review and waiver where that simply cannot be reviewed at all.
Why aren't you forfeiting you say, the judge says, anybody have a problem with these jury instructions? And everybody goes, no. Why isn't that a waiver or a forfeiture or whatever you want to call it?
Because there is so much that could go into instructions, that needs to go into instructions here, that can be missed. And it is not just the defense attorney's job to get all the instructions out there. It is, of course, that's the primary job of the judge, the trial judge, but it's also a job of the prosecutor to know whether this is something that's going to be appropriate and maybe trip you up on appeal. Now, of course, had there been a fully fleshed out discussion and we went through all the prongs of Alexander and counsel had said, that specific unanimity instruction there, I don't want that. But that's just not what we have here.
We seem to be in this limbo where the test now seems to be, well, it can be deemed unpreserved and we won't look at it if, from the record, it looks to us like it was a strategic choice. And so we're left in the position of going, could this be strategy or not strategy? And if the defense in a case isn't that it wasn't done on this day or that day, but it never happened at any time, then why is it obvious error that affects substantial rights?
Well, I'll take a step back. Where I started with Justice Meade was it's just not reasonable strategy ever for a defense lawyer. I'll say ever categorically.
Well, I think she moved on to a second issue, which is it harmless when the defense is, it never happened?
Oh, okay. Well,
And the
yes.
evidence is either it
Thank you.
happened 100 times or it never happened at all, essentially.
Right, and the way I comprehend, the way I think about a specific unanimity instruction is perfectly congruent with a defense of it just never happened at all. And that is because at bottom, what it is asking jurors to do is to scrutinize cases like this where there's bare minimum and very generic allegations of abuse, and 10 counts of them, to go through and to really think, rather than a gut-level reaction to what we all have as the most probably serious and difficult type of cases where we tend to have gut-level reactions.
But are you saying, I just want to be clear about your argument, are you saying that it's up to the judge to give specific unanimity in every case with a range of offenses under one count, that the judge must do it, failure to do it is obvious error? Are you?
Yes.
Okay, all right.
I
so
would
that's-
say that. I would say that. Of course, you have to satisfy the prong. If this court is not going to go with structural error where we started
Right.
or some other remedy, then you do have to establish that third prong of the obvious error test.
So-
Absolutely.
So just, what do we do with the instruction that was given at the end, the re-instruction in response to the question, that basically time doesn't matter?
Right.
Should that instruction be given in these cases?
No, I don't think it should be given.
It's
I
not
think-
an incorrect statement of the law, is it?
Except when there is ambiguity about whether or not it falls outside of the statute of limitations or within the
And that was
element
the
of
original
offense.
purpose of that instruction, is really a statute of limitations question.
Right, or the element of the offense here was under 12. So I don't think that that's presented here with these facts, but it is confusing, certainly in this
Did it
context.
aggravate the situation by giving that instruction?
You know, it aggravated it, and it also, the requests for specificity, if you will, by the jurors indicate that they were perhaps wondering whether they really needed to identify discrete events for each of these. So I think that that is something, back to Justice Meade's question, back to Justice Connor's question, that indicates there is harm in this case, because jurors were wondering, do we have to be specific? What about these date ranges? And then they were told, no, essentially you don't need to worry about that detail.
Can I take you briefly to your Confrontation Clause argument?
Please.
I'm just looking through the jurisprudence and the scholarly writings and everything. There seems to be a consistent theme that the right to cross-examine sort of cures all ills that occurred, and there's really some strong language in the decisions. And Wigmore especially says, confrontation in its main aspect is merely another term for the test of cross-examination. The right of confrontation is the right to cross-examine. Confrontation involves a subordinate and incidental advantage, namely the observation. So he's saying, Confrontation Clause, you got cross-examination, you're good to go. The fact that you might not be able to, see is kind of sidelight. That's what the jurisprudence seems to say.
Yeah, I will agree that the federal jurisprudence, certainly since 2004, and the Crawford decision seems to say that. And I think that's where Wigmore was going with that. There are multiple purposes, including federally. There have historically been multiple purposes, including a face-to-face
Well,
confrontation.
let's look at history, because that is an important part of when we have to go to ground zero and figure out what our Confrontation Clause means, correct?
It sure is.
Isn't it correct that at the time of the adoption of the Declaration of Rights, that the issue about child testimony was whether they could do an oath or not? And if the child was deemed competent, then they would come and testify. If the child was not deemed competent to take an oath, to understand the oath, routinely they would let in the hearsay statements of the child. And doesn't that indicate that it wasn't a constitutional issue?
So, first off, Your Honor, I'm not aware of any case law specific to Maine and specific to Section 6 that regards that, or more generally, with the Sixth Amendment or some other state analog of that.
Well,
I simply don't know
Crawford
about
talks
that.
about it, and Crawford is about the common law, and there's a brief reference and a citation to the Indiana Law Journal that talks about this in some depth.
Oh, and one of the things, of course, is in 1820, there was a decision made in Maine to adopt a very specific provision that says, confronted by the individual.
And we got rid of the face-to-face from Massachusetts, correct?
Well, I don't know that we got rid of it. I think that
We did not
We didn't
adopt
take
it.
I think that it's fair to say, based off of this court's case law from the 1800s, that they understood confronted by the individuals to mean face-to-face. It certainly, this court has said so many times in the 1800s. The point about, Your Honor made, though, about whether a child is deemed competent would require some kind of finding, some pretrial finding, that is simply not here on our facts as well. There is no finding that this individual in this case was not competent, and she was, in fact, if you watch the video, a pretty mature-looking child. I think it would be quite a leap to say that somebody like that is
think
not
he was turning it off.
competent.
I
I'm
saw
not
you
sure where we
glance,
are.
but finish your sentence. I didn't mean to.
I think I have finished my sentence. I'm certainly,
We're a little confused on our timer here. I think I'm going to start doing this when it's yellow.
okay, thank you. Just wave your hands, I will be quiet, I promise.
You've gone from digital to manual here, manual lights.
And where cross-examination was required, in many of these cases, there was also just an understanding that direct examination, meaningful direct examination was required. The technology that we have nowadays is something that finally has made saying so, in this case, necessary. 100 years ago, 200 years ago, simply not required. It was not necessary to say, no, you can't bring in a video recording of a witness.
Thank you, counsel.
Thank you.
Chief Justice Stanfill, and may it please the court. It was not error for the trial court not to give a specific unanimity instruction in this case. The victim in this case, who was only 10 years old at the time of trial, disclosed multiple forms of gross sexual assault and unlawful sexual contact that occurred multiple weekends per month over a period of more than a year. Although the victim did not describe every single instance, she described multiple specific acts and incidents. State v. Reynolds requires that a jury be properly instructed on the issue of specific unanimity when it is generated. Reynolds points back over and over to State v. Hanscom, which clearly states that on request, the jury should be instructed on specific unanimity, and references State v. Fortune, which says the same. There is nothing to suggest that it is obvious error, or even error at all, for a trial court not to step in and give a specific unanimity instruction sua sponte. In fact, that would likely be an overstep and could contravene legitimate trial strategy. In this case, the defendant, through his counsel, contended that none of these instances ever happened and tried to attack the victim as an over-sexualized youth with a motivation to lie about her strict grandfather. He affirmatively approved of the jury instructions that were given through his counsel. There is no obvious error, and to the extent that specific unanimity is an issue at all, it could be addressed in the post-conviction review process. Additionally, there were no overlapping dates in the indictment between the gross sexual assault and the unlawful sexual contacts. Turning to the issue of the Confrontation Clause and the admission of the Children's Advocacy Center interview, a state constitutional argument was not argued or developed at the trial level, but in any event, the state constitution and the state precedent doesn't require anything more than the federal constitution does. The Supreme Court and this court have recognized that the Confrontation Clause allows for the admission of certain hearsay statements. Title 16, Section 358 is consistent with similar laws being used and upheld across the country. In State v. Adams, this court said that when the declarant appears for cross-examination at trial, the Confrontation Clause places no constraints at all on the use of his prior testimonial statements. In this case, the victim took the stand. She testified on direct. She identified her abuser for the jury on direct. She testified that she was interviewed at an earlier date, and she clarified a few points, such as what she meant by the word private part in her earlier interview. And then she was subject to a robust cross-examination in which her truthfulness, inconsistencies, memory, character, and exposure to sexual material at 10 years old were attacked. And she answered every single question asked of her. The Confrontation Clause was not violated. Thank you. I'll take questions.
Counsel, you seemed, going back to the specific unanimity issue, you seemed to suggest that it wasn't even generated in this case. Is that what you were suggesting? Putting aside the issue of whether it was preserved.
I think that if it had been asked for, it probably would have been given, and I think that would be appropriate, but
Would it, if it had been asked for?
if it had been
Would it have
asked
been
for.
error not to have given it?
I don't know. It may have, I do think there's an argument that it's not generated because there was a range of dates alleged that did not overlap for the gross sexual assaults.
But then the jury was instructed that the dates don't matter. And so if they had been instructed that it had to happen during this range for this count and during this range for that count, that would be different, but that is contrary to what they were instructed.
Yes, I understand what you're saying. They were instructed that a date is not the essential element of the crime, and it's that the crime happened that matters. But I think that the concern for specific unanimity being that they identify some particular occasion, the fact that there is a range of dates that doesn't overlap cuts in favor of the state's perspective on
But
it.
isn't that the problem, that if you allow it to be any dates, and whether or not they were overlapping, and they were told it could be anything, and you don't give a specific unanimity instruction, isn't that, essentially going to end up being a likely violation of Article 1, Section 7, requiring unanimity in the conviction?
The instructions were an accurate representation of the law that the date is not an essential element of the crime.
I can understand your reluctance to take an affirmative position because, as we said in Russell, we reached the merits of his argument because on appeal, the state has taken an affirmative position conceding that specific unanimity was necessary, and that kicks the door open for review. So I'm guessing we're not going to get you to concede that it was required.
I would not concede
Okay,
that.
all right, understood.
Can I ask a confrontation question? Do you agree that under the the statute about these interviews, that the interviewer is gathering testimonial statements?
Yes, I would say the statements are testimonial. They're likely to be used in prosecution.
And therefore, do you take the position that in Maine, we have adopted under our Constitution the testimonial test for confrontation announced in Crawford, which then rejected the old reliability test in Roberts?
Tell me if I'm not understanding your question correctly, but my understanding, and I think this answers the question, is that a witness needs to be available for cross-examination to alleviate any confrontation issues.
Well, I mean, in Roberts, and for a long time, the concept was in the federal courts that the concern, the purpose of confrontation was reliability. And hence, there are some Maine cases that talk about how reliability is the key, and some of them are cited by the defendant. But then, in Crawford, written by Justice Scalia, he says, no, it was all about whether something was a testimonial statement or not a testimonial statement. And is that change, does that mean we don't look at reliability anymore? Does that mean we've adopted that? How does that affect our review of those older Maine cases that the defendant cites?
Well, I don't know exactly how it would affect the older Maine cases, but in this case, I think it is a non-issue because reliability, one of the things that was talked about, I believe, in Crawford is that the ultimate test of reliability is to be subjected to cross-examination, which in this case, she was.
You're basically saying it doesn't matter which test we apply, the old Roberts test or the newer Crawford test, that this kind of situation where you are allowed to have some cross live would allay the concerns under both.
Yes, and particularly in this specific case where she did do a bit of a direct and then was subject to a lengthy cross-examination.
And the cross is not limited by the scope of the direct, correct? Under the statute, they're allowed to ask any question not limited by the scope of direct.
Correct.
Even if you took
And under the
even
new
if you
rules.
took a broader view of the concept of reliability and stretched it out to, include something like almost credibility, I mean, wouldn't testimony or statements that are given closer in time to the event in a more relaxed environment be perhaps more reliable? I understand there's the whole cross-examination component of reliability, but I'm not talking about that. I'm just talking about purely from believability perspective. Wouldn't the statements closer in time to the event be more believable?
That is certainly the state's perspective. It's both closer in time, and if you look to the testimony that went into this bill, now law, there was testimony about how the CAC process is actually more reliable, and research suggests that it's more conducive to honesty and clarity by children than without the CAC and have them talk to potentially a caseworker, a police officer, a prosecutor. It is set up to be tailored to children's needs. And I would also just add that the statute requires that the questions be open questions, not leading questions. And the judge has to review the CAC and make a determination that the questions were not leading. And in fact, in this case, there were a couple of questions which got kept out by the judge because it's typical at the end of a CAC, whether it's generated or not. I think it comes from DHHS to ask if there were any photos taken or any images shown, and I think another question is about drugs and alcohol. And although she had not disclosed it in her initial disclosure, when asked that question, she had said that her grandfather had shown her pornography. And that was kept out because it wasn't something that was brought in by her. It was something that had been brought up by the interviewer. And so, yes, that was a long-winded way of saying, yes, the state certainly considers it to be more reliable, and I think there is research to support that.
Could we return just a moment to the specific unanimity issue? There seems to be something artificial about the fact about the state's role and whether the instruction is given or not given, whether they concede or whether they recommend it. And if everyone knows it's a fact, there's a bunch of events that took place within a range of time, but it's only alleged as one charge in the indictment, one count of the indictment, that would trigger, those facts alone would trigger the appropriateness of the instruction. And Attorney McNamara floated the concept that why would any defense attorney not request it? I mean, just a bright line rule there. Are we focusing incorrectly on the state's role in this process? Should we simply be looking at the judge and looking at the facts of the case? Is it artificial to put sort of the burden on the state to say, yes, it's appropriate, yes, we request it, no, we're going to be quiet? Does it really make a difference what the state does?
Well, moving forward, I'll certainly explore it more, but I don't know that it's really the state's role to be opining on what jury instructions for the defense should or shouldn't be given.
But it is the state's role to ensure that constitutional rights are also met. And the Constitution requires that a verdict be unanimous.
Yes, but in this case, there really was no discussion about it because the defense was always that this never happened.
So if we set up that kind of dichotomy where the defense is it didn't happen, then are you suggesting then specific unanimity simply doesn't matter?
I wouldn't, take a stance that says it doesn't matter, but I do think that you can say it may be a legitimate trial strategy not to ask for it. I think it could be a legitimate trial strategy to have the opinion that a specific unanimity instruction could presuppose that this happened, and it's a question of do we know for sure when did the state,
I confess I'm a little bit on Mr. McNamara's page on that one. I cannot imagine why a defendant would affirmatively waive a specific unanimity.
And isn't it fair
instruction.
to assume that in almost every case, the defendant is going to say, I didn't do it?
Well, it may be. I mean, there are cases where the defendant doesn't say anything and the state just can't prove it for whatever reason. And there are other defenses, I suppose. But yes, your point is well taken. I mean, a lot of times they're going to say they didn't do it at all.
So what do we do with these cases where the charging instrument actually chooses a date range? It says count 1 between January 1st and December 30th of 2020. Count 2 is between January 1st and June 1st, 2021, et cetera. In other words, the state chose discrete ranges. But yet the jury is instructed that that doesn't matter. And, but they're also not told they have to unanimously agree on any particular incident. And for all we know, the jury thought it never happened in 2020 or whatever other period. I mean, what is the purpose of having even a date range if it just doesn't matter?
Well, for a crime like this, she had to be under 12. And the jury is also instructed that any inconsistencies, I don't know the exact language, but any inconsistencies about the dates alleged or uncertainty can be considered as to the strength of the state's
But why is the
case.
state even bother to put dates in other than just, under 12?
Well,
If it doesn't matter. I mean, that seems to be the position you're taking, is it just doesn't matter.
I'm not sure how else you would prove that someone was under 12 other than to allege a date. But I just don't think it's as plainly instructed.
Well, the victim
as-
testifies it happened when I was 10. I mean, that's
Well,
how you do it.
doesn't specific unanimity mean that the jury, all members of the jury have to decide that the crime occurred on a specific date and a specific place?
It requires that they need to find beyond a reasonable doubt that the crime occurred on one specific occasion that they all agree is the same occasion. But the state would not have to prove it happened on June 1st, 2023.
Right.
So as long as everybody agreed that this crime occurred on a specific occasion that we all agree, then specific unanimity would be satisfied, which I don't think departs that
Do we-
much from the
Do
instruction.
we know whether the jury agreed in that way?
Well, they found him guilty.
Thank you. Mr. McNamara, I believe you reserve some time for rebuttal.
I'll pick up with that question. I think we know that they probably didn't agree. They asked a question, the judge said, let's not be concerned about the dates, essentially. 4 minutes later, they came back with a verdict. I think it's pretty telling that that happened so quickly.
Would there be a problem if instead of instructing generally that date doesn't matter, as happened here, or sort of re-instructing that it didn't matter, if there hadn't been a specific unanimity instruction, but let's say they had said, you know, the date doesn't have to be specific, but you do have to agree on an incident between, for count one, that it happened essentially in 2020. And then in count two, you have to agree it happened in the first 6 months of 2021. Would that have taken care of?
I think what would have taken care of it is a specific occasion for each charge. I think, and I understand why we're talking about jury instructions here, but to answer the question about what do we do about those discrete charged time ranges, I think it's really incumbent upon the state to argue, to elect, to identify what specific allegation are we talking about when we're talking about each count. So that's less an instructional
You mean
issue
to
there.
specify in the indictment or in closing argument?
They can specify it in the closing argument, because
Okay.
you don't always know how the testimony is going to come out, but be able to identify these
Can I
counts
ask you
are
about-
tied to that testimony.
One more side I want to talk to you about. The state said this waiver thing is a valid thing. If it's validly waived, then you don't get it. And if that's the case, that comes out in the post-conviction review. So is that a sufficient stopgap that if PCR came up later and during the testimony, the lawyer testifies, no, because of what we did here, I specifically didn't want that because I wanted the jury to focus down on the big picture. Absolutely, I waived it. Then isn't that a sufficient protection?
No, I don't
after the
think so.
fact.
And I don't think so because, again, it is not just the defense lawyer's duty to be offering this. And on the record we have, which the trial judge is charged with making, with getting everything on the record, with getting a charge conference on the record we have, it just wasn't contemplated. And we've also talked, of course, about the strategy. There's just no reasonable strategy here that would fit that. The defense was, admittedly, it didn't happen. But the addition to that is, and we know that because it was such sparse, uneven, generic allegations. That's the way I understood that closing argument to be. And that is exactly why we're talking about the need for specific unanimity. Without that specificity, we're just saying there's maybe something there, but this is such a disgusting case, we don't want to get into the details.
Without specific unanimity, does it also run the risk of getting into a problem with double jeopardy?
It does. And we don't know what is coming out the other end of a juror's verdict. And I'm not sure if that's yellow or
It's actually red.
It's red.
But you can answer the
not
question.
colorblind. I think that is a potential problem. We don't know what a verdict means without A, the prosecutor electing, and B, a specific unanimity instruction. Thank you.
Thank you. Thank you, counsel, for the argument this morning. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. As is also our usual practice, Attorney Lenz, I understand this is your first argument, but for a high school argument in front of us, and so we would ask if counsel wished to come back and take the greetings of the court.
All rise.
And you may be seated. The matter now before the court is Kennebec 24-125, State of Maine versus Aaron Engroff. Counsel are present. If you would identify yourselves by saying your names for the record, starting with appellant.
Good afternoon, Rory McNamara for the appellant, Aaron Engroff.
Good afternoon, Shannon Flaherty for the State of Maine.
Thank you. We are being streamed live on the web, I think. Okay. And do we have working lights now? Perfect. Okay, with that then, Attorney McNamara, if you'd like to proceed, we'd be happy to hear your argument.
Thank you. May it please the court, counsel? As far as I can tell, this case is the first to reach the court in which a lack of a speedy trial caused actual detriment to a defendant's defense. Because of the blitz, because of more pressing cases, and because of insufficient resources.
Is the actual detriment, since you let the green light be on right away, is the actual detriment, when you say that, the admission of the CAC interview?
I think that's one.
Because of the change, the enactment of the statute in the intervening time?
Yeah, that's the biggest component, I would say. Of
What other
actual
actual prejudice is there?
some of the more quotidian forms, I guess, if you will, of, he had to have a chaperone with, and he still does, with his own children. He lost his military career.
So there were effects, I mean, what I hear you saying is there were effects on him, but the timing issue is really, and I'm not, I don't mean to minimize those
Right,
effects.
right. Specific to the trial. I
Yeah.
understand now. I'm sorry. In addition to the CIC video, the prosecutor made an argument that says that memory is a fickle thing, indicating that, well, that's something that those inconsistencies perhaps in the testimony or in the evidence, well, that's something that we're.
And that's highlighted in this case because of the
Delay.
Real letters and things like that, that the memory was clearly.
Right, right. And the CAC interview in this case was taken 2 years before the trial. In the age of a child, that is quite a significant chunk of time and then to have the ability to go back and to watch as a child your video.
But doesn't that also equally to some extent, to your benefit? In other words, that the length of time and the fading of memory and all is like, isn't that really help you argue that it's not reliable?
I think maybe in some cases it could. It wasn't a strategy that was chosen in this case, wasn't one that
But
was
that's a
pursued.
strategic issue.
Certainly, but I think there are always going to be reasons for why a defense is or isn't chosen. And in some cases, across the board, if we're thinking about other cases, I don't know whether that inures to defendants or not. Here,
Should we look, when we're looking at factors, should we follow or depart from the federal factors, being length of delay, reason for delay, defendant's assertion of the right, and prejudice? Are there other factors that we should look at under a Maine constitutional analysis?
I think, as from the Winchester decision, certainly the Norris decision, as I see Justice Connors looking at you askance, I think she wrote the Winchester one. I think we know what the...
Askance?
I don't mean to mischaracterize if that wasn't askance.
I've never been askanced before.
The main factors are very similar to the federal ones. There may be some nuances difference, and I don't think in either federal jurisprudence or state jurisprudence as to the Constitution that it's necessarily limited to those three factors. There may be other things.
Well, so my question would be, when you talk about prejudice, I think we previously have identified it in Winchester, incarceration, adverse publicity, anxiety, and concern, as well as impairment of the defense. What I hear you doing is identifying that there are other factors, in other words, even short of incarceration, that in this case, the period of time that he was on bail was challenging more so than sometimes because of the inability to see children, the loss of the armed services position,
Inability to find a
and
job.
other significant restraints on his movement or freedom.
Right, and I do think that that is something that, if I'm recalling the Winchester decision, is cognizable as a speedy trial form of
So
delay.
it's not just incarcerated or not, that the
Correct.
amount of restraint on freedom, even if bailed, would be relevant?
Correct, I think that's something that is relevant, and those are well articulated.
Is your argument, counsel, that the trial judge made erroneous findings or conclusions with respect to the factors, or that the factors that she added up amount to an abuse of discretion on her part?
And there's always going to be a gray area there, so bear with me as I answer that. I think as to the factors, we largely as to the findings, we largely defer to those. But this difficult area in between is there prejudice via the CAC video? Excuse me. And I think there's some difficulty in this case because Justice Lopez, who heard the speedy trial motion, didn't know that the CAC video would be considered. So I think to the extent that's a finding, that's not prejudicial over there, I think there's a problem there. Justice Lopez didn't know that was coming in. This court certainly does and should not defer to any to the extent that's a finding. I think above that, it's actually a conclusion of law to determine whether or not that's prejudicial over there. And the same would go to the judge's consideration of the inability to hold a date certain trial.
Well, I was going to ask you about that. So the judge, Lopez below, held the period from October 23rd to January 24 when a date certain wasn't given to the defendant against the defendant. Isn't that just a scheduling issue like the other scheduling issues?
I don't think so. And I think
Okay.
the
So
reason
you're okay
why-
having that held against the defendant?
Oh, I'm sorry, maybe I misconstrued the question. Thank you for clarifying. I must have,
To my
I'm so-
surprise.
I'm so used to
Mr.
saying no to
McNamara, you don't
everything we
usually get in so easily.
I'm sorry, I misheard the question.
I'm just, the period of October 23rd to January 24, the judge held that against the defendant in the analysis of the cause for the delay. Isn't that really a scheduling issue, just like the period from June to October?
It is. It's a scheduling requirement that should be counted, I don't want to say against the state, big state of Maine, if you will.
Against the court?
Right, against the court, the legislature and the executive branch, if we're honest. And the reason is, the very definition of a judicial system is a forum to which people come to litigate their dispute. It's an essential thing to be able to have date certain trials. We can't have corporate officers lined up in the hallway or out-of-state witnesses lined up in the hallway for weeks on end waiting to have a trial
Was the request in this case for date certain or for special assignment?
for a date certain,
That's
Your
what I
Honor. So back to Justice Douglas's question about whether these are findings or conclusions, I tend to think these are conclusions about what, as a matter of law, is proper prejudice, what, in the matter of law, counts as a delay caused by the defendant, and they're not so much findings. But even if they are findings, there is this question of who made the findings and were they able to consider.
Well, let's say the defendant requested a date certain for trial on the date of the indictment. Does everything after that request get counted against the court and the state?
Yes, I think it must. I think that's the job of the courts, is to be able to litigate a case where the witnesses will come and be able to be convene and testify as to compulsory process. And certainly, I understand that there are difficulties in the Maine judicial system providing that right now. But I do think that if we take a step back, everyone here in this room recognizes that's something that the courts do need to be able to provide.
Well, there was, I think we can all agree, there was a big backlog that was in part caused by COVID. So how should we acknowledge, if in any way, any of the impacts of COVID? It's not really the state's fault that there was a pandemic.
Certainly not the state's fault that there was a pandemic. The backlog at this point was over 2 years old by the time defendant was indicted. And it was coming up on, if I've done the math, 3 years by the time it would have been 4 years by the time trial was ensuing. And at some point, when we have findings from the National Center for States Court that for the intake caseload of this judicial system, we're lacking 9 judges, then the legislature, the executive, has simply not fulfilled the duty, the obligation to provide for timely processing of these cases. So I think it being so far after the fact that I don't think that that's a serious.
And the interview argument is basically, if we had had a speedier trial, this bad evidence against me wouldn't have been admitted. Is that really a good reason to say that you should count it against the state?
Well, I disagree with your characterization, of course. I think that I would put it as the excusal of the complainant from testifying at trial, which we all know from our experience is often a situation where there's uneven testimony, there are inconsistencies, there are holes in credibility that can only be elicited on the stand and can only be developed on the stand, as opposed to a video camera up in the perch of a room with a girl
But
with a
there was
hat
the
on.
ability to cross and ask all those
I don't
questions.
think that's adequate, and I don't think that's adequate for constitutional reasons, as Your Honor knows, but it's a form of prejudice. If you ask defense counsel, what is oftentimes the only defense is to sit back and see if the complainant can make credible allegations in the solemn circumstances of a courtroom, as we have always required. And oftentimes, that burden is simply not carried. And to fundamentally change that game, when defendant had asked for that, in contemplation of this, when the legislature passed that bill or was processing that bill in the spring, I think defense counsel became alert to it and said, oh my God, that's a potential threat to my client. Let's hurry up and have a trial. We need this trial before this becomes effective. And then was perhaps relying for a while on the fact that the state didn't indicate until 2 days before jury selection that it was in fact going to proceed under the statute. And that's where the prejudice comes in. In addition to the fundamental changing of the game, defense counsel didn't vet adequately that CAC video, as he said candidly several times, to know the reliability of the examiner, to know what techniques, what protocols may not have been followed. And that wasn't done because he didn't know until the last minute that that was coming in. So that's all part of the prejudice. We haven't discussed the role of Rule 48B here. And I do think that that's, based off this court's case law, slightly different. And I just want to mention the 2 ways it seems to be different. If I may just mention these 2 ways.
Quickly.
All right. There's no invocation requirement that I know of, and specifically, explicitly, it is a goal of 48B to ease court congestion, which it seems like exactly these circumstances. Thank you.
Thank you, counsel. Attorney Flaherty.
May it please the court. This court should affirm the trial court's legal findings and the jury's verdict for the following reasons. First, the trial court properly denied the defendant's motion to dismiss based on speedy trial grounds after weighing the necessary factors pursuant to the rules of criminal procedure, case law, and constitutional jurisprudence. Second, the defendant's right up to confrontation was not infringed because the defendant was able to cross-examine the child victim, the very definition of confrontation. Third, the trial court did not err in admitting the victim's statement pursuant to Section 358, as the statute created an exception to the rule of hearsay, a procedural evidentiary rule that applies at the time the trial occurs. And finally, even if this court were to find that the trial court erred in admitting Section 358 under the original version, admitting the victim's statement, such error was harmless and the conviction should be affirmed. And I'm ready for questions if the court has them.
I'm going to go over to the speedy trial issue again. First, I want to ask you a similar question to what I asked Mr. McNamara. Do you agree that when we start talking about the effect on the defendant, in other words, we identified incarceration, but that the greater restraint, I mean, some bail conditions are more, have greater restriction on liberty than others. Do you agree that's a factor? It may not amount to incarceration, But being on PR bail with no conditions is a different ballgame than being on cash bail with a lot of significant restrictions.
I do agree, and I also think it also fits into the second part of that, where it talks about, the public, people being aware of it. I think it fits a little bit into both. And it's true, some bail conditions, you're just not supposed to commit new criminal crimes. Sometimes you're on house arrest. So I think that is a fair consideration the court can take.
And then secondly, I'm going to go back to the same question I asked about the period from October 23 to January 24, in asking for a date certain, as opposed to a special assignment. Isn't that really a court scheduling matter? And I understand it's not the state in the sense of the district attorney's office, so I'm clear on that. But isn't that really an issue of scheduling just as much as not getting it done during the Blitz or October?
I think traditionally, yes, but in this case, a little bit different because of how many times the defendant himself asked for continuances. So the difference in this case than potentially just pure scheduling issues is that originally this case was indicted in early 2023.
But he didn't move to continue this. I mean, he just said, I need a date certain.
Every single time the case was set for a trial date, he said he wasn't ready. And that's the state's perspective. He needs special, specific trial dates for his out-of-court witnesses. And while I understand the difficulty of out-of-state witnesses,
Back up, though. I mean,
Okay.
needing a date certain, whether it's for out-of-state witnesses, experts, or the other kinds of things that happen, just even sometimes just the number of witnesses, is different than not being ready for trial.
I think that's fair to say. Maybe that's not the correct way to phrase it. But what I would say is that this is not a situation where there was one time where he asked for date specific and then the court adhered to that and then we went to trial. This happened 3 or 4 times.
And the court wouldn't give him a date specific.
But the court couldn't give them that. They couldn't give the ability to
Well,
have, and that's,
But isn't that a question of, again, court scheduling?
I think it could be possibly weighed against court scheduling. I think the court is aware that that is weighed less heavily in the Winchester analysis.
And I understand that,
Right.
so.
But from the state's perspective still, and maybe I don't totally agree with Your Honor, is that in many ways it is a continuance. And I understand that it might be because of a scheduling issue, but in this case with the defense counsel at trial, there was originally a motion for bill of particulars, and then there was a waiver. That waiver happened in April of 2023, and then he reasserted the right to speedy trial in June. And Justice Lopez, as is in the appendix during that docket call, made it very clear, like, we can go if you're ready, and he wasn't ready. He did change the way he phrased it, but he wanted specially set dates for out-of-court witnesses or out-of-state witnesses. And then when he was told that we can't do that for this particular docket, he didn't necessarily, from the state's perspective, prepare. And what I mean by that, is it inconvenient for a person to be on call for a month? Yes. The state deals with that all the time. But you're going to subpoena someone for the entire month, and then eventually you will get those dates specific. So just because it's a little bit more difficult, I don't think that rises to a constitutional violation to the right to a speedy trial, especially when it's the defendant.
Well, that doesn't in and of itself, and I'm not suggesting. I mean, I guess I'm just trying to figure out how we count the time. And then the second follow-up question to that was, let's say I think that that's a scheduling issue. What do we do with the finding by Justice Lopez that it should be found against the defendant?
I think the court has to do an abuse of discretion analysis and see if she went above and beyond what was in the evidentiary record, and if her finding, even if it's under a clear convincing evidence standard, is it so beyond the evidence that she had before it that she made a completely erroneous decision? I don't think so. I think if you look at how she articulated it very clearly in that particular diatribe when she gave her oral argument or her oral findings.
Diatribe?
I know, that was a weird word, and I tried to fix it.
Kind of the wrong word.
It was a weird word, and then I tried to fix it quickly, but sometimes, you just get, tricked up. But during her oral findings, she clearly articulated, which is the better word, that she was weighing against the defendant because of how many times he was told we couldn't give specially set dates, and he continued to ask for them. And I do think that he could have been prepared if he had wanted to at that point.
So let me ask about the invocation. In Winchester, we said, for the Maine Constitution, that's really important. And the defendant says, well, but does that mean the time before the invocation doesn't get counted at all? That wouldn't make sense, would it? Do you agree that when we're looking at the first issue, the time of the delay, it doesn't matter when the defendant has invoked. The key is that they did invoke and indicated they wanted a speedy trial at some point.
I think that's fair, and it kind of goes into part of the argument that I had made about the sword and the shield of the waiver. But to answer your question first, I don't think it's fair if someone doesn't, if they have multiple attorneys and they decide not to assert their right until 14 months in, that entire 14 months gets deleted. But I do think it's important that the assertion be made. The issue that I had in this particular case is it seemed as if the speedy trial right was being used as both a sword and a shield for the defendant's purposes, in the fact that he would waive it and then reassert it. At times, it seemed convenient for
Well,
him.
did he waive or just agree it could be told for a period of time? I mean, there's a little bit of a difference.
He specifically, defense counsel specifically stated in June of 2023 that he had waived speedy trial in April of 2023, and that in June he was reasserting it. I believe Justice Murphy later on in one of the following arguments, because this was argued several times, said that she believed it could be considered tolling, maybe even in the original waiver back in April, she said it would toll. But the difficulty, and I think that appellant counsel mentioned this, and your honors know, as former justices, is that the trial docket,
Actually, we're still justices.
sorry, I said trial, but the trial docket is insane. It's a very busy, ever-moving piece of everything. It's always changing. So the idea that you can waive speedy trial right and then reassert it and be on the exact next docket call, I think is not realistic. It's not something that can happen on a regular and ongoing basis. So the ability to waive your right to speedy trial when it's convenient for you because you're doing more research or more investigation and then reassert it isn't fundamentally fair.
So you've referred several times to the realistic ability to manage our trial dockets.
Yes.
And obviously, and I think this is what you were saying, as many of us know that firsthand.
Yes.
But isn't that a problem? I mean, isn't the whole idea of a right to speedy trial is that the fact that we as a judicial branch are unable to accommodate all the trials that need to be held is still, doesn't mean it's not a violation of the speedy trial.
I'm never going to get up here and say that we're not having trials as much as we should, because we're not, and I agree with that. I think that we have to look at this case very specifically, and you have to make a very case, factual-based analysis. This is not a situation where at every docket call that Mr. Engroff appeared at with his defense counsel, he said, I'm ready to go at this docket call on any dates you give me. Every single time he was given that opportunity, even months in advance, specifically if you were to look at the October letter in the appendix that Mr. Bowe had sent, he was told you have, this is going to be December for potential January trial dates, without even attempting to find a way to make that date work after needing a speedy trial, asserting it over and over again. He said, that's not going to work for me again. That's not something that rises to a constitutional violation. When you're given the opportunity for a trial over and over again and it doesn't work for you, that's not a speedy trial violation from my perspective.
Let's go to the prejudice issue, because under the federal and the state, it's considered the most important issue.
Yes.
What's your response to his claim that if I had had this done earlier, this CAC interview wouldn't have come in?
The way that I remember when we were arguing this and when I was reminded in the brief, it was this idea that the CAC interview would never come in without this new statute, and that's just not true. Under State v. Adams, this court has found there are other rules of hearsay where the CAC interview could have come in different formats and different ways.
But isn't that important, that those are different formats in different ways, and it is dependent on how the direct testimony of this alleged victim would unfold? And in this case, the advantage to the state of the CAC interview is, of course, you basically don't have to do it direct, other than, is that what happened? Yes, it is. And so you may have gotten in some, not necessarily all, of the CAC interview, but you may not have, depending on how the testimony went.
That's completely fair, but I would twist that around a little bit. The state's prepared, but so is the defendant. From the beginning of this case, that CAC interview was in share file in discovery. He had had it from the inception. He knew what she had alleged in that CAC interview. The idea that he was unprepared for what her allegations were because she didn't do a robust enough direct, from the state's perspective, is not logical, because you had the CAC interview from the very beginning. There was never a bait and switch of the CAC you didn't have is now going to come in. That was the basis for the original investigation, and it was in discovery from the beginning of the
Is there
case.
some reason why the state didn't notify the defendant earlier in the game that, yes, we plan to use it?
I think motions in limine are filed when we actually know the case is going to go to trial. I will say, I was the one who filed it a few days before, and not to play tit for tat, but I know that the defense counsel also filed motions in limine right before the trial happened. And just so if it matters to the court for best practice, it's now in share file every time a case is approved an indictment to try to avoid this issue. But I don't think there is any time constraint about motions in limine. Those come up when the case is going to trial.
I'm going to ask Attorney McNamara in just a moment that if the video came in under the previously existing jurisprudence, what about that specifically prejudiced his client? You won't have a chance for rebuttal on that. Can you anticipate what he might say and say, no, he would not have been prejudiced if it came in simply under the previously existing jurisprudence?
He wouldn't have been prejudiced because, as the court mentioned earlier, I think Chief Justice Stanfill, prior to the trial, when the state was prepping its witness, there were some Brady Giglio issues because of lack of memory. And I know the memory is a fickle thing. My rebuttal has made everybody upset. But when you look at that, when it comes to prejudice, they were on notice that there were some things that were inconsistent within that. So say for a recorded recollection under State v. Adams, say she had forgotten more things and she couldn't remember and the CAC came in. On cross-examination, you still have the ability to challenge the fact that she couldn't remember, that she didn't understand what was happening. And that's exactly what happened here. To go back to the confrontation issue a little bit as well, I think what's very distinct and unique about this statute, and I did do a long string cite in my brief, and I apologize in advance, not really, it was fun to do. But I did a lot of research about other states, and our statute is very conservative compared to other states. In some states, the child is in a different building, they don't even see the defendant, and they are through one or two-way screens. In this case, the victim had to walk in, she was subject to a direct, how minimal or robust it was, and she was subject to cross-examination, and the defense counsel was able to cross her not only on the Brady Giglio letters that had been provided, but also from the CAC video. He was able to question her memory. And despite how my rebuttal, I thought, went, the state didn't win on all of the charges in this case.
But in other states, there are certain limitations on the use of that broader video. You have to show, for example, a specific harm to the child in that particular case, while here it comes in automatically. And I guess my abstract question is, does the looming change in the rule of evidence, should that be a factor considered when determining whether there's been prejudice under the Speedy Trial Act?
So I have two slight answers to that, and I know I have the yellow light. But one thing I will say about the statute is that it does require a motion in limine. So the CAC has to go through a rigorous evaluation by the court, and in our particular case, and when it comes to prejudice, the idea that they weren't aware of how it was going to come in or on what foundation it would come in, as defense counsel, there is still, and as the state, we could have had a situation where they brought the CAC in to show prior inconsistent statements. There has to be some level of preparation to understand that in a trial, you never know exactly how it's going to go. But in this case, what is great about this statute is before trial, both parties know what the CAC is going to say. In many ways, it's a benefit to both. Thank you for your time.
Thank you. Mr. McNamara.
Thank you. I'll begin with Justice Mead's question. It's very important to see, for the jury, to see how that direct will develop. In the example of the Adams case, there was considerable testimony to the effect that the complainant in that case could not, and this is required for a recorded recollection, could not adequately recall what had happened. And it's important for the jury to see that on the stand.
On direct?
On direct exam.
And then they're impeached with the video after the fact.
They're impeached after.
What happened here, this was front-loaded with the videos, so that was all out there.
Correct.
And that's the prejudice?
That's part of the prejudice. The complainant isn't even in the courtroom when the video is displayed. So the jury is not able to see her reactions that might be happening as that's going on. Also, in addition to that, in this case, the uncharged conduct that comes in under this CAC statute, Justice Murphy said it's about 50% of the allegations in this case was uncharged conduct. I'm not sure how that comes in without a direct testimony under other hearsay examples to that effect. I want to go to Justice Connor's point about, which I think is a good one, about other states having requirements of certain findings. This case, this court in the Twist decision said, we will approve under the federal constitution, but also we see no reason to have a different conclusion under the state constitution, which is telling. If there is severe psychological and emotional damage threatened to a child, then we will relax these requirements. There's no finding here at all, of course, in this case, nor is there one required by the statute.
You indicated that the child is not present when the interview is played.
In both the cases.
Could they have asked for the child to be present?
They probably could have. They probably could have. I don't know how that would have shaken out. The problem in this case, in this case, was that it actually came in through the CAC interviewer rather than the child, and there's supposed to be sequestration of witnesses, so there's some difficulty there in doing that. Your Honor made a point in the first argument about common law, about affidavits and whether a child was competent to testify. I think it's important to remember that in many conceptions, including some at common law, of what a child was, that cut off at age 12. So in other words, age 12 is an important part of that. Also, again, I will question whether that is accepted practice in the law court since 1820 when we have adopted the confrontation clause that we now have. And that's all I have for a presentation, unless there are any questions.
8, 7, 6.
Right there, I take that as none. Thank you.
Thank you, counsel. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. As is also our usual practice, Ms. Flaherty, somehow, this is your first argument here, other than the high school, so we would ask if you wish counsel to come back and take the greetings of the court.
All rise.